So in this case, we're trying to get in another excited utterance, and of course, we are able to. The defendant murdered Penny Cheney in a particularly horrific way. He tried to kill her once before, and what the prosecution is trying to get in this case is the fact that he previously tried to kill her. That would be something under 404B. And undeniably, if you try to kill someone one time, that definitely is something that can come in under 404B to show your motive on the second occasion. So the question then is not whether this is admissible. The question is the method of proving it admissible? Because in the prior case, the way that the prior attempt on Penny Cheney's life, the way that the prosecution is trying to prove this is through her statements. So the defendant had previously tried to drug Penny Cheney, and she says that in her first statement, she said he drugged me and threw me out of a window. And then in the second statement, she said he drugged me and I jumped out of a window. Now, when were these statements and how do they apply to the excited utterance? So the first statement was made as Penny Cheney is running from the defendant's house, screaming for help, and saying, as she's screaming for help, she's intermittently screaming for help and saying that he drugged her and threw her out of a window. That pretty undeniably fits the definition of an excited utterance. She's describing the event that caused her excitement. She's barely away from the house. She's running. She doesn't know if he's chasing after her. Undeniably, that's an excited utterance. So she then goes to this apartment manager's office, and they call an ambulance, and 15 minutes later, the ambulance arrives, and Penny arrives at the hospital, where she tells the story to a nurse. And when she tells the story to the nurse, it's slightly different. She says that her boyfriend drugged her and that she jumped out of the window to save herself. And so two questions. One is this period of time too long? Has the excitement of the event dissipated to the point that we no longer regard this as an excited utterance? And the court says, no, this is a fairly short period of time, and the nature of the event was so startling that we would believe she would still be laboring under the anxiety from it. So then, what about the fact that there are different stories? In the first instance, she said he drugged her and threw her out the window. In the second story, she says he drugged her and she jumped out the window to save her own life. Now, the court says that and this is really interesting, that reliability is not the basis for admitting an excited utterance. That a person may actually be wrong when they utter an excited utterance. But that what we're trying to prevent is fabrication, and that if you're still under the excitement of the event, then you wouldn't have had a chance to fabricate the story. It may be wrong, but it's not fabricated. And so remember in the present sense impression cases we were looking at, the court said there that the almost instantaneous description of an event ensured both its sincerity and its accuracy. And here with excited utterance, at least in this Arizona case, the court is saying that sincerity is important, that we want to make sure that while you're still laboring under the event, that while you are still laboring under the event, that you wouldn't really have the opportunity to concoct a story to benefit you. But the court says we're under no misapprehension that statements made in this condition are actually accurate. So it's not accuracy, it is an assurance against fabrication that we're worried about. And the best example of that is this particular case in which there are two separate stories. Now, both of them suggest that the boyfriend tried to kill her, but one of them really makes the story far more extreme and definitely makes his homicidal intent more obvious. And so, but the second one calls into doubt the first one as to what exactly happened. The court says that's not something we worry about with excited utterance. The fact that the story might be wrong is not our concern. Our concern is whether you're lying or not. And so earlier on in the semester, I mentioned that there are many reasons why we don't like hearsay. We're worried about the perception of the declarant. We're worried about the accuracy of the declarant. We're worried about the memory of the declarant, and we're worried about the honesty of the declarant. But I also said that there will be exceptions that will allow hearsay in, even when the nature of the out-of-court declaration is not free from some of those concerns, and that hearsay law is most concerned about intentional lying. And if you can show that the person's not doing that, you can probably find a hearsay exception to get the statement in. If the circumstances suggest fabrication is not a possibility, you can often bring the statement in, and the excited utterance is certainly a way to do that. So once again, excited utterance, you have to be still laboring under the excitement of that particular event. The statement has to be about that event, and the amount of time that's passed between the event and the statement can't be great enough to call into question our belief that under all the circumstances you are no longer laboring under the trauma of the event.